So we were talking about this passage from a copyright status to the public domain. Works are born by default into copyright. Why? Because we don't require any formalities or any registration in order for the copyright status to kick in. Therefore, anything we produce by default is protected with copyright rules in most jurisdictions that we know. The members to the Berne Convention are almost identical to the members of the UN, so we're talking about most jurisdictions known. Now, the length of copyright protection is usually the life of the author plus 50 years. That's the benchmark that the Berne Convention has placed, but most jurisdictions have already added 20 years to that. So you could easily assume that it's life of the author plus 70 years, which is the case in the European Union member states. For so long as the work is protected under copyright, it means that by default, unless the author has made any other choice, and here is where we will go to Creative Commons, which is a choice, a different choice made by authors. Unless there's a different choice, unless there's a different signal to the users, you should assume that the work is under copyright. So if I write a paper and I upload it on a web page that is not an open access repository, it's just my own personal web page, and I don't even put a sign there. I don't need to write that all my rights are reserved. The work, unless signaled otherwise, if the author is still alive and for 50 or 70 years plus, is protected under copyright laws. After that, it falls into the public domain. The public domain is the space where works become public, become commons by law. In between, before we go into Creative Commons, we also have these two gray areas that I mentioned earlier, Orphan Works and out-of-commerce works. This is how we arrived here. Out-of-commerce works are works that not necessarily, they might still have commercial value, but for the publisher that initially published them do not. Another gray area that is overlapping also with non-out-of-commerce works are orphan works. Orphan works are works whose right holder, author or publisher, is very hard to find. In order to ask for a license, you need to access a right holder in order to negotiate, in order to ask, how can I use this work? If you cannot access the right holder at all, let's say all you have to is a name, perhaps a date of birth, it's not clear what happened later. Maybe the publishing house has stopped working. We're talking about older works that are not old enough to be in the public domain, but still their copyright status is unclear. And we do find a lot of these works in our research and in libraries quite a bit. So that's one gray area. An additional intermediate step that is now being introduced with Creative Commons is exactly as you see on your screens. This signal from the author to users that I have actually licensed my work under Creative Commons license, under one of the many Creative Commons licenses. And therefore, one, you don't need to find me to negotiate with me. There is an automatic sort of, there are rules that kick in that are standardized. We all understand and respect what X license means, what Z license means. One, and two, we're still in the realm of copyright, but you don't need to assume that I will exercise my rights under copyright in the way that the copyright framework gives me. This is why we think of Creative Commons as sort of an alternative to copyright law. It is a structure within copyright law. It is not an alternative, strictly speaking, but it allows for the authors to take initiative and say, I don't want the default. I don't necessarily want my work into the public domain. I might, and I have the option to signal that as well, but I might want to allow users, without the need for them to come and negotiate with me, to do a number of things with my works. And with that, we can delve into all the licenses. There are 6 licenses, and there's also a public domain dedication tool, which we don't count within the licenses. Creative Commons Attribution License, the CC BY. What does this mean? Work by X author, right? This paper is written by Panezi. The only thing that you want when you use this license is that you want the work always to be attributed to you. You might choose a CC share alike. That's the SA signal. There, and we'll have one slide for each so that we sort of repeat them again and remember them better. Here you add one more condition. What each license does is that it signals to users what are the conditions of use. So in the first, the condition of use is that you attribute the author. The second, in the second one, the condition of use is that you tell the author, if you reuse it, if you use my work in your own work, then you have to license your own work the same way that I did. You have to go Creative Commons as well. You can do what you want. You cannot use my work. If you use my work, you will continue the chain of licensing that I started. Why? Because I like this type of licensing. I want to give you access to my work. I want you to give access to your users, since you're building upon my work. The Share-like Creative Commons license comes really close to open source. Now, non-commercial Creative Commons. Here, you give a different permission for commercial uses and a different permission for non-commercial uses. What are commercial uses? Uses for, yes, please. Yes, Peter.
It's very interesting because you mentioned earlier the moral rights, and as I understand, at least 2 of them are. One is, and they're not alienable. You always have the moral right.
You always have them.
And one of them is the I think it's called paternity. That is that you must be identified as the author.
As the author.
And so what does the CC BY license add to that, if you already have it? That's my first question. And the second one is this thing about reuse, because there's an integrity, the right of that your text maintains its integrity. So what's the relationship between these inalienable moral rights and what you concede, let's say, with the CC BY license?
Perfect. This is a great question because it helps us also understand the distinction between having rights and exercising them. What Creative Commons did was to think separately about the rights that you have by default from copyright laws, international, supranational, or your national laws, and the ways in which you want to exercise them. So what is allowed in the sphere of copyright law and generally in property law is to exercise your rights of property ultimately in the way that you want. You cannot be forced to sue someone for using your work without attribution. So even if moral rights are inalienable, it doesn't mean that if I know, for example, that your book is used by Serge, and Serge is actually putting his own name and circulating your work with his name. If you're aware of this, and you're okay with this, no one can force you to take action for your moral rights, which is a principle and a general idea of how we exercise our private rights. You can only be forced, quotation marks, to exercise rights in the criminal law arena, which created a space for Creative Commons to say, okay, we don't need to bear the costs of every individual negotiating with other individuals. We don't need to keep bearing the cost that the default sort of copyright protection brought about. At least if we had registration, as it was the case before the 70s, we might be able to know who has made the effort to register their work. Therefore, we know that they want their rights to be protected. In an era where, and in a system where everything is protectable, unless you object to that, or unless you give a different license. Creative Commons said you can give a signal to users on how you want to exercise your rights. And once you have the right to abolish yourself, not your rights, but to basically say that I'm not going to exercise my rights in this, if this makes sense. And with integrity, it's more or less the same. You have allowed, so even in the case of copyright protection, first, you cannot be forced to exercise the right, and second, you can always consent. With the licenses there, you consent a priori to new uses and reuses of your work, saying that I'm fine with everything, so long as you use the same license, which is the second one, share alike. You set your rules without negotiating with the user. They're standardized, explaining, if you had come to me and we had negotiated, this is what I would have allowed to you. You can always do that. You can always relinquish rights. There is a bit of an issue with regard to the exercise of moral rights, particularly with paternity that you said, and ghostwriters. Technically speaking, European jurisdictions are insisting on moral rights, in the sense that if the paternity of the work becomes apparent, reveals, then for the public, the author is still the real author. But would that mean that the ghostwriter will entail costs before a court? No. So that's the trick. You don't exercise your right. The third license, we were in non-commercial, CC, BY, and NC. What happens when you signal this third license? You're giving different permissions to commercial users and to non-commercial users. To non-commercial users, you don't put any restrictions other than attribution. To commercial users, you are basically saying, no, you have to contact me. I will probably license under more conditions, including compensation. I leave my paper here free. You can use it for your papers. You can use it for educational purposes. A non-for-profit organization can use it. But if you are a publisher and you found the opportunity to grab a good paper that is licensed under Creative Commons license by NC, you cannot include it in a collection and start charging for it. So I separate commercial from non-commercial uses. Commercial uses are very largely sort of interpreted. Also, uses from commercial players sometimes can be interpreted as commercial uses, even if they don't have immediate, they don't result in immediate revenue. For example, in the online context and the online business models through advertising, etc. There is another abbreviation, the non-no derivatives, CC by NCSA, and also Shareline. Excuse me, the ND. Yes, Lotte.
Yes, I would like to ask a question that we have seen lately, at least with one of the journal publishers that, I mean, we have seen many SAGE articles. So, if I don't know if you can share again the screen where you had the three with
Yes.
copyright, Creative Commons, and before this one, exactly, and the public domain. So what we have seen, I mean, we are seeing is that the copyright can remain then indicated as such with the authors of an article, for example, Politics and Society, for example, Journal of Conflict Resolution. A little bit, not always the published version, but sometimes it can be the accepted version, but sometimes it is actually the final version, okay? And next to that, you see the Creative Commons, even Creative Commons by. So you have copyright, the authors, and then you have under that Creative Commons. And do you have any comment on that in relation to this, what you just said? How best to use that then?
Yeah,
together.
Yeah. I think this reinforces what I wanted to clarify, that Creative Commons licenses operate within the copyright structure. They're not, there's another movement called copyleft. There's also, there are also movements that are basically defying copyright. And we start then at some point talking about also peer-to-peer file sharing and a number of illegal platforms. So when we talk about Creative Commons, we're not in that sphere. We're within the structure of copyright. This was, I think, what the founders of the nonprofit cleverly did. They knew the Creative Commons, they knew the copyright system. Lawrence Lessig from Harvard Law School was one of the initiators, and basically worked around that system, understanding the default, the fact that the rights are there unless you decide not to exercise them, unless you give a signal to users on how you want to exercise them. And this applies also in the context of journals. So if a journal accepts this model, meaning that it doesn't want to put a paywall in order to access the work, then it's perfectly compatible that it will publish the work or a version of the work, as you said, and still use one of the Creative Commons licenses signals. At this point, also these signals, figures have become quite sort of, users are accustomed to them. So it's quick and easy for us to understand. Can I use, I'm a commercial user. The minute I see an NC, non-commercial, I know, let me move this a bit. The minute I see the NC sign, and I have the signs here as well. The minute I see here, for example, attribution non-commercial share alike, and I'm a commercial user, I know that I cannot reuse commercially the work that I have access through a journal. Even if the journal is perfectly open, perfectly accessible. And practically, to go back also to both questions, practically, this is the differences between having the author having a cause of action before court and the author not having a cause of action before court. So Creative Commons license are also cultivating safety for users to know that even if a publisher, an author starts claiming otherwise, if you have proof that you used the work having being aware that it's licensed under this, for example, license, if on a website, as you said, this sign is used, then the court will respect this, meaning that the license is binding, and is binding for both parties. It's also binding for the publisher or the author that gives this signal. The only different thing, the only differentiation between using Creative Commons license and actually negotiating a license is that you have a generic sort of standardized way that doesn't leave a lot of room for negotiations, therefore a cost-effective way, because every time that you go online and you find something, it would be extremely burdensome to try to contact right holders. You have a very easy standardized system, not a lot of flexibility. You cannot play with different terms. If you want flexibility, you need to stay within copyright, which is something that we will talk about later with regard to our relationships with publishers, particularly with regard to our relationships with book publishers, where it is more empowering to stay within the framework of copyright, because you do have individual negotiation, you do retain your rights and can tailor to the needs. As you see, for example, here, you don't have, when you look at all these options, you don't really have options that give you a certain time frame, that this is how you're going to use my work for the first year after publication, and a different way for the next years. Practically, you might want to release your work under together with a publisher for 1 year or 2 years, and then when you're ready, you go with Creative Commons, one of the licenses, because you think that you've already sort of protected your work enough, you've already received the revenue that you wanted, etc. So the lack of flexibility is helpful in the way that it's cost effective, but there is not always the best option for every context. And this is a very good segue also to the discussion we're going to have later, what to choose and when. So to finish here the options that we have, you can also have a sort of the most protective version, Creative Commons, attribution, non-commercial, and no derivatives. No derivatives means you cannot modify, you cannot create derivatives, even translations, for example, without my permission. And now a seventh, it's not a seventh license, the licenses are the 6 that you see also in red, but a dedication tool, the public dedication tool, as it's called in the Creative Commons framework. It's basically a tool that dedicates your work to the public domain. Again, going back to Peter's question, you have the right to say, I don't want to exercise my copyrights, my rights over copyright. I want my work to go immediately into the public domain. What does this mean? No rights, I'm done. I don't, arguably, moral rights are still protectable within the European Union particularly, but generally speaking, public domain means that I made the work common property. It's not my property anymore. I decided to make the work common property. After 70 years after my death, I don't make this decision voluntarily. It will happen. But I can decide earlier, because I like the idea of donating my work in the common sphere of knowledge, that I make my work public. I donate my work to the public domain. Therefore, public dedication too. And here I have just added each symbol so that we remember them and we are familiar with them. So attribution, the license lets others distribute, remix, adapt, build upon your work, even commercially. That's important because it's not the NC. So even commercial use, you can let your work out with a CC BY license, and commercial users can make profit further from your work, so long as they credit you for the original creation. The most accommodating of licenses. It's not the public domain. Public domain is even more accommodating. Attribution share alike. This license lets the same, remix, adapt, build, so long as you credit. But then they need to license their own creation under the identical terms. What does this mean? They also need to do CC by SA. They also need to license under Creative Commons with share alike license, including commercial uses. So all new works based on yours will carry the same license. So any derivatives will also allow commercial uses. And that's also important to know, that since you are basically defining what your next user will do, and you have not taken commercial uses out, therefore the next person will also not take commercial uses out. Interestingly, this is the license used by Wikipedia, and you can think of what kind of uses Wikipedia allows when you see that. It wants attribution, it wants further follow-on licensing in the same way, and it's perfectly fine with commercial users using their content. No derivatives. The license lets others reuse the work for any purpose, including commercially. However, it cannot be shared with others in adapted form. Adapted form translations. It is in written form, let's say, moved to an audio form. And credit, of course, needs to be provided to you because the buy is always there. Attribution non-commercial share alike. The license lets others remix, adapt, and build non-commercially, as long as they credit you and license their new creations under identical terms. So non-commercial share alike is what makes sense. It wouldn't really make sense to do non-commercial without adding the share alike, because then you might block non-commercial immediately, but then the reuse further on could be commercial. So it is logical that non-commercial and share alike go together. That's the most logical option.
Sorry, Arkiri.
Yes.
I'm Carlotta.
Hi,
Probably
Carlotta.
I lost your part of your explanation. I'm at the desk of the library now. A question: a
Yes.
commercial company can use a CC by SA share alike for publishing open access, for example. You told us that open access and Creative Commons is not the same, but I mean, without having a revenue from the publication.
Yes, because it basically respects the share alike component. Share alike does not necessarily mean that they need to, for example, stay within the Creative Commons framework. Anything identical to it, so an open access publication will basically mean the same thing. So therefore, yes, that's a great question, because we were talking about how do we define commercial uses earlier. Commercial uses it doesn't mean that a commercial player, a commercial actor, is always engaging in commercial uses. They would have to prove, for example, before court usually, that they are acting non-for-profit. It's not by default that every action of a non-profit organization is non-for-profit. The other way around is a little bit more difficult. So commercial users, of course, commercial actors, of course, can engage in non-commercial uses. So in the example that you said, yes, a commercial actor, a publisher that you think of as commercial actor, can indeed be one of the beneficiaries of this particular license, so long as, for this particular instance, they're not making profit. They're not engaging in a commercial transaction.
Thanks.
There is a very slight differentiation where you can prove that indirectly their use is commercial. And these are cases that before courts are debated heavily because, of course, the actor will say that so long as it's free, there's no commercial use. Sometimes when the compensation is people's data or entry into a platform that excludes some people, you might be able to argue around an argument of a commercial player that their use is non-commercial. It doesn't mean that there's no room for controversies within the Creative Commons license, but, and this is something that we're going to talk about in a little bit, the pros and cons, this framework has really brought controversies down, has really kind of provided a clear, easy sort of framework to regulate the relationship between authors, users, publishers. And I don't think that I have the last one. The last is not a license, it's the seventh, as we said, sort of option where you dedicate your work to the public domain and then anything goes. If you dedicate your work to the public domain, a publisher, a commercial publisher, to use Carlotta's example, can commercialize your work. Who provides the Creative Commons license? Sometimes we forget sort of the structure that is behind. It's a non-for-profit based in the US in Mountain View, started in 2001, if I'm not mistaken. And the organization has non-commercial purposes. It also advises authors, it promotes open access, first of all, and works together with educational institutions, particularly in the US, and advises stakeholders on how to move from a traditional copyright system to a Creative Commons system. Does licensing under Creative Commons means that I lost my copyright? I think that from what we have presented here already, you can guess this answer. The answer is no. We are still within the sphere of copyright. You can still change your mind. Licensing is not perpetual. Even in the context of individual negotiation, you can renegotiate with your parties and with your counterparties and change the terms of licenses. What, of course, you cannot change is whatever uses happened and whatever uses were made of your work while you were licensing under Creative Commons.